Good day, good evening, Professor Amos and Abulia. It's nice to have you here, sir.
Good evening. Nice to be
Good,
here.
good day, everyone, and welcome to the live stream of the Center for Community Law. You are tuning in right now. You are watching a crucial moment in our legal and democratic landscape unfold. So the big question we're asking today is right at the thumbnail that we use for this live event. Is this a U-turn or is it true justice? So we're dissecting a massive development out of the federal courts that have sent shockwave through the political and legal community. As you can see from the timeline and our advertisement prior to this time, we're looking at a complete pivot, moving from a definitive December 2025 ruling to a brand new June 2026 first hearing ordered by Judge Dashen himself. When a judge reverses his own ruling, the ripple touch everything, especially when institutions like INEC are caught right in the crosshair of the conversation. So before I bring our legal, our minds, and our political analysis Professor Enabulili today, I would like to ask everyone on the live chat to engage with us. If you have a question, you can drop it while we actually go through the chat box to respond to you. So we want to lay down the facts clearly to both our audience and our professor who is here for context. So there was an incredible rare judicial targeted bend that happened last month where a presiding judge over a case that was filed demanding that NDC, which happens to be the political party that Peter Obi is contesting for presidential candidates, there was a suit that was filed for it to be deregistered, owing to the fact that it fails to meet the minimum criteria to be recognized party. About 20 ruling, the judge actually ordered that INEC recognizes apparently in June 6, a fresh ruling was given by the same judge who actually faulted the previous judgment. He had to sit on his judgment again and reverse it. So it has really caused a lot of shockwave through the legal individuals and political analysts. So today we want to just go through, want to review again what exactly is the implication of this occurrence, Professor.
Okay, can you hear me?
Yes, sir.
Okay, thank you, Fear God, for asking me to do this again. I'm sure it was from questions from or responses from the last one. Just to correct one thing, I'm not a political analyst. I'm just going to speak to the legal facts as they are, and my understanding today is to look at the decision of the court of 10th of December 2025, because there's been analysis here and there. Some people have called what happened on that day default judgment. A lot of explanations have been given. So I think that it is important to know what transpired in that judgment of 2025, December 10, because that's what will make us understand or give us the opportunity to comment on what has now happened. I'm not going to be commenting on the judgment that he gave last month. I'm just going to focus on that of December 2025. And to begin with, Justice Issa H. Dashen is the judge that gave both judgments. He sits as the presiding, he sits at the Federal High Court in Lokoja in Kogi State. So it's a Federal High Court decision. And In this case, it was the NDC that went to court. NDC had submitted a registration application in 2017. So between 2017 and 2025, a lot of correspondence between NDC and the INEC. And it wasn't just the NDC, there were other political associations that were seeking registration. So in September 2025, INEC wrote to the NDC to tell the NDC that, look, the logo that you are proposing is similar to the logo of the APC, and I struggle to see the similarity between a victory sign and an umbrella,
Actually,
and a boom. So NDC responded around on 22nd of September to say, look, yes, we have got this correspondence. In fact, INEC said we are going to stop your registration on the basis of that because of that similarity. So NDC wrote back to say, we can't see that similarity between what we have proposed and the logo of the APC. In any event, if you are insisting that that similarity is there, we are happy to change our logo to something else so that this registration can proceed. But they didn't get a response from INEC, and so they did a pre-action notice to say, if we want to go to court because we haven't got any reaction. And so that was how they went to court, submitted an originating summons before the court. And originating summons is just inviting the court to interpret, certain laws and that have been presented before the court. And of course, the African Charter was there, the Constitution was there. Basically, the NDC was asking the court to determine whether INEC was right to refuse its registration after, in their opinion, they fulfilled all the requirements. So INEC responded. INEC responded to that application, and in responding to that application, INEC raised the preliminary prescribed time limit, but the court overruled that preliminary objection and won the case. Just for context, in that, what NDC was asking for, they asked for several declarations. One of them that I've highlighted here was for a declaration that within the meaning and intendment of Section 72A of the 1999 Constitution as amended, Section 71, 2, 3, 4, that's subsections 1, 2, 3, 4, and 76 of the Electoral Act 2022, the refusal of the defendant, which is INEC, to register the NDC despite compliance with the requirements of the registration amounts to an infraction of the Constitution and statutory rights of the plaintiff. So in the declaration that was sought, NDC was basically asking that the court should compel INEC to register because NDC felt that INEC's refusal to register wasn't based on any correct interpretation of the law, but that there was more to it. And so the court heard that case. The reason why I felt it was proper for me to read out the second prayer that NDC was asking for is because you see some analysts, even other that is now having their own issue, they came and said NDC did not fulfill the requirements, that it was just the court. The court just said, go and register. NDC didn't fulfill the requirement. But as at this time, NDC was asking the court to say, we have fulfilled the requirements. Can you ask us? I'm not sure NDC will just go to court and vacuum. We'll just go to court without having fulfilled the requirement. In fact, NDC had done that as at 2017, when they did the application, they did comply with the requirements as at then. And so the court gave its decision. The funny thing about, or the important thing about the decision of the court, I'm going to be reading some paragraphs from the decision of the court, and that will help us see that perhaps, I do not know, because reading through this judgment, I can say categorically that the judgment of 10th November 2025 was a sound and well considered judgment. The judge considered every aspect of that case.
Wow.
Peace movement was introduced into that matter by INEC in their counter affidavit. INEC came initially. INEC said, if you follow the trend of my thought since, INEC said the logo resembled that of the APC, a victory sign and a boom. I can't see that
Exactly.
resemblance. Yeah, except if we are talking about something else. Then, in their counter affidavit, INEC now said it resembled that of peace movement party. And in response, the NDC said peace movement party is not even part of the associations that apply for registration.
Exactly.
It's not a registered political party. It's not even a registered entity. So,
like that.
yeah. And so, how are we now saying that it resembles that of that should be a basis for refusing to register? And so that I don't talk too where I should lay out the judgment and decision of the court, you know. So with regards to now, requirements, even payment of the with reasoning, without concrete reasoning. If the reasoning of the court, which is what is I'm going to read out a few of the things that the court said, with regards to logo. If you have the judgment, for instance, if you've seen the judgment, you go to paragraph 18 of that judgment. 17, maybe we start from 17. Page 17 of that judgment. The court said, talking about refusal to this is the court speaking. Curiously, in the defendant's counter affidavit before this court, an entirely different basis was introduced, namely that the plaintiff's logo allegedly resembled a symbol belonging to a registered association belonging to a non-registered association known as PNP. The plaintiffs deny ever being told this and insist PNP movement is neither an existing political party nor among the short-listed associations before the defendants. The exhibits relied upon by INEC do not show that this PNP grant was ever communicated to the plaintiffs at any time. So before that counter affidavit was filed, PNP was not in the picture. Yes. PNP was never communicated by INEC. PNP was nowhere. So
interesting.
Suddenly, when the matter went to court, INEC was now shopping for justification not to register not to register the NDC. I'm not sure INEC thought that the NDC, because of all the shortlisted parties, it seemed as if associations, it seemed as if it was the NDC that went to court. So INEC saw that it was going to be very impossible to say a boom resembles a victory sign. And so INEC came up, this PNP came up. As at that point, there was no application from any association called PNP or that closely want to become a party to this suit. And the court responded to that and said, it is well established that a party cannot approbate and reprobate. In other words, a party cannot blow health and code. You cannot say it is code now, and later when you get to you say it's white, and you come and say no, it's not black. Blow health and started quite a number of cases and said NDC, that's the letter that was written by INEC to the NDC in September 2025, saying that they will not register the NDC because their logo resembled that of the APC. The judge, that was what was exhibited as Exhibit NDC3. He said Exhibit NDC3 makes no mention whatsoever of PNP, and the belated reliance on PNP in litigation is therefore an impermissible afterthought which carries no probative value. So the court said it was an afterthought. The court said INEC was blowing hot and cold. So at what point did that afterthought now materialize to become a material fact in 2026? When the court itself had said that this was an afterthought. I can't entertain this. This is nonsense. It's too late in the day for you to bring this on. It is impermissible. So what the court said was impermissible in 2025 became permissible in 2026. What the court said was an afterthought in 2025 was no longer an afterthought in 2026. So that what the court that
Exactly.
2025 now came and reversed itself. So the court was well aware of all of this. You begin to ask yourself, was there something drumming for this judge? Was there something that happened that we did not understand? Was there something that really happened? It is not just that. If you go to the issue of the logo, the court came and said, with respect to the allegation of logo similarity, Section 222E of the Constitution, INEC to reject a logo merely because it virtually resembles of an existing party. It's even saying that the law does not empower them to reject it because it resembles that of an existing party. Not alone now, in 2026, he's not saying that government was wrong because the logo resembles that of a non-existing party. So it's a funny thing.
It's contradictory, actually.
It's a funny thing, yeah. He said, the mischief the framer sought, I'll just leave that. He said, it is not. So for him, it is nonsense. You can't come and tell me that this logo resembles that of the APC, even if that was the case, and say because of that I won't register you. He wasn't even talking about a non-registered. So now in 2026, the same judge is now saying that the logo, a non-registered party, INEC should have refused to register. Reliance on perceived similarity underscores procedural arbitrariness. Administrative discretion must not be exercised capriciously or in bad faith. The judge himself is the one that brought in bad faith, accused INEC of acting in bad faith. So at what point does what was bad faith in 2025? At what point did this cease to be bad faith? Did what was bad faith in 2025 cease to be bad faith in 2026? Those are questions that are very important. Then he went on to say further on the issue of logo. Just give me a bit because I don't have it on top of my head. I just need to read from the judgment so that nobody will accusing me of making anything up.
Exactly. This really left a lot of people skeptical because people are wondering what exactly went wrong. Is there a background story that something happened behind the scenes we can't go out? So like before a judge should actually reconsider judgment again, at least have to be like another court should at least requested for a review of that judgment, but nothing like that was done, and the same judge just sat on the judgment again and reviewed it.
Yeah, yeah. And so, and on the ground of similarity of logo, which he dealt with, you can see that this is something I would call issue estoppel. This says this he dealt with it with finality. There wasn't anything that he left hanging. He said that
Yes.
even if you say, okay, if there was resemblance with that of the APC, which he found not to, which INEC abandoned, INEC disowned that justification I gave her. He said, even if that were the case, INEC didn't have the power to suspend, to refuse to register based on that. You know, last time we were having this discussion, I mentioned when we're having this discussion, I mentioned something about vested rights or acquired rights following a decision of the court that was not appealed. You know, this court gave a decision. That decision was not appealed. Can you see me? Fiago, can you still see me? Fiago has disappeared. So that decision the Constitution permitted it to do, and INEC had ratified or obeyed that decision. The court said this. He said on the issue of third party of the right of third parties with respect to this. The court said something that's very important that I think I should highlight very quickly. Let's see it immediately. I think I will leave that for a moment and come back. Give me a moment.
So are
The
we
court
going to
was saying
force
that, look,
INEC? Are we going to force
yeah,
INEC with the current state of things and the recent rulings? Are we going to force INEC, or are we also going to be scrutinizing the judgment in 2025? So who is actually right now, who is the major factor that we should be looking at? Is INEC to be faulted?
that's an important question, but I will come to that. Let me just finish what I wanted. Now, the court said, I'm just reading from, I'm quoting him now. He said, it is no answer to suggest, as INEC does, that the plaintiffs are not prejudiced. Without registration, their members are precluding from sponsoring candidates or participating in forthcoming elections. Their political voice is silenced. That constitutes prejudice of constitutional magnitude. So the judge was saying, no registering them, when in his opinion, his finding, they've satisfied all the requirements, constituted a prejudice, in the sense that it's going to preclude them sponsoring people for election. You know, it's going to affect people that want to contest under their banner, that is going to silence their voice. That as a result of that, it's a violation of a constitutional prejudice of a constitutional magnitude. That's very strong word. Of a constitutional magnitude, that's the word prejudice is. Now compare not registering a party at all. A party that is not known.
Actually,
You've not registered the party. And you are saying at that point that it will prejudice people want to contest, who will be desirous to contest under its umbrella. That not registering it is a prejudice of a constitutional magnitude. Compare that to deregistering a party that was already registered. People have bought forms. The party has advertised. A lot of people have followed the party. Compare that. If at that in 2025, when they were not registered, the court said it was a violation of a prejudice of a constitutional magnitude. How can you now compare it now that other third parties have acquired interest under it? For instance, Obi and Kwakoso would not have gone under the umbrella if the court had not given that decision and it wasn't registered. The gentlemen and women up and down the country who have bought forms, who now want to contest under the NDC will not have bothered to go to the NDC if it wasn't registered. After all, nobody's campaign, nobody bought form, other form right now. Nobody bought the form of PNP because they're not registered. They're not recognized. So having recognized the party, INEC has registered the party. It's an invitation to people to say, now you can come and buy form. You can come and seek your political ambition, pitch your political ambition. And it's an invitation to the voters to say, oh, you can vote people who have come under this umbrella. So when you are not saying no registration, if the same judge said no registration is a prejudice of a constitutional magnitude, is it open to the same judge? Going to your question, for instance, now, you say, is it the judge to blame or INEC? Is it open to the same judge to now say the registration is a neutral act? It doesn't matter. You can deregister. Is it open to the same judge? Something must have gone wrong somewhere. This is also particularly so because the judge himself heard that upon the totality of the facts and evidence presented, I find as a fact that the plaintiffs have demonstrated compliance with the constitutional requirements under Section 222 and the statutory thresholds under Section 7 and all of that of the Electoral Act. So the judge himself came to the conclusion. He came to the conclusion that the NDC complied with all the requirements. So when you hear politicians or whoever saying that NDC did not comply, oh, Peter Obi was reckless, he should have. Whoever raised this judgment will have no doubt at all.
Yes, that's not factual.
That at all. This is a proper that needed to be dealt with. And let me just go to the orders that were made by the judge. Before first of all, you ask if it was the fault of INEC or the fault of who is to be blamed. Is it INEC or the judge?
Yes.
My answer is as good as look at this judgment, how sound this judgment is, and a judge that knows this man knows the law. His lordship knows the law from his analysis, from what he did. He knew exactly what to do. So if the same judge is coming around to do something different, I should begin to think that there must be something drumming for him. I don't know what that was. I'm not to make excuses for him. But I think the judge, the matter is already at the court for appeal. So it's going to be difficult for me to begin to say, oh, is the judge, is this? That's why I'm careful today. I'm just analyzing what the judgment said without saying, oh, the judge was wrong, the judge was right, without commenting on what happened in June. As at the time we had our conversation on Friday, an appeal had not been registered. But I hear now that an appeal has been registered, so I can't comment on that judgment. But that's why I'm limiting myself to this, just to put it out there that this was what the situation was. This was what the court had. This judgment is not on appeal at the moment, so we can comment on it. It's not on appeal. We can comment on it. So that's why I'm commenting on it. And now this was the order. This is the judge gave. Then I will stop here. He said the judge gave the following orders after determining that the PNP, the logo, the INEC cannot rely on that INEC was very hot and cold. They cannot approbate and reprobate. The associations that apply for registration, and so even if it were the case that there was a resemblance with that of the APC, INEC did not have the power to not register, and that refusal to register after compliance with all the requirements was a prejudice of a constitutional magnitude. Would cause a prejudice of constitutional magnitude against nowhere at all. Nowhere at all that the judge said that, oh, looking at all of this, I think that the PFP, because there's a provision for necessary party. You can join a necessary party if there's a party that is required. The judge, because this party is required for this matter to be determined. The judge didn't leave anything hanging, determined everything, came to make the following orders. 20 in page 22. This is 21. 22. The judge made the following orders. That's 19. Maybe I should just read out. Let me start from the second order that I made. I leave the first order because I can't seem to find that page. I think pages. He said, it is declared that having fulfilled, that's the second declaration that the court declared. It is declared that having fulfilled all statutory and constitutional requirements under the Constitution and the Electoral Act, the political association as a political party constitutes of their constitutional and statutory right. Constitutes an infraction on their constitutional and statutory right. It is declared that upon proper interpretation of section of the Constitution and the African Charter and the Electoral Act, the defendant's refusal to register the NDC amounts to a violation of the plaintiff's freedom of association and their right to political participation. So instead there was a violation of their freedom of association and their right to political participation. It is further declared that defendant has no discretion or residual power to refuse registration once an association complies with the requirements of the Constitution and the Electoral Act. So the judge making a definitive declaration that, look, once an association has complied, you cannot. INEC does not have a discretion. That compliance had happened. Then he now made the following orders. It is hereby ordered and directed that defendants shall forthwith register. It is hereby that's 23, 24. All steps necessary to, let me find 24. Sorry, I think it's a bit organized. Necessary to include the name of the NDC in its register of political parties, publish and list same, and relief sought but not expressly granted in this judgment is deemed refused. Any relief sought but not expressly granted in this judgment is deemed refused. He signed 10th of December 2025. Honorable Justice Issa H. Dashen, presiding judge. That was the judgment that he gave. Very clear. He left nothing. Yes, he left nothing to chance. He left nothing to doubt. So the question in the mind that should be in the mind of everyone is whether, having given that such a judgment, whether there was anything that was remaining to be done. That's how many people will be saying that, oh, the judge was functus officio. Many people will be saying that some people said want to look at it from the position of a default judgment. It wasn't a default judgment. It was a full and final judgment. The only party that was entitled to appear before the judge to be a party to that case was a party, which was INEC. And so
yes,
that's it. I hope my job is done now.
Yes, I
Fear
think
God.
they
Yeah,
want question.
you're welcome.
So the airline yesterday actually carried out NDC has filed an appeal requesting for a stay of leave, and the pressure, they also mounted pressure on INEC, and they've been able to successfully upload their presidential candidate on INEC portal despite
Yeah.
the recent judgment that was given last month, June 2026. So
Yeah.
we look forward to what the outcome is going to be by the appeal court.
On appeal. Yeah.
Yes, sir.
We'll be back here to talk about that. By God's grace.
Thank you very much, Prof. Thank
All
you very
right.
much, Prof, for the time.
Fair God.
Yes. Thank you very much, Prof. It's always great to have you with us. All right, sir. Bye.